Susan, can you hear us?
Do we need those little pucks?
You need to mute that one.
No. Yes, I can hear you. I
Okay.
can hear you and I can see you all. Perfect.
And then Stacy, can you hear us?
Yes.
Sorry, y'all. I think it's still on mute because I can't hear you.
Can you hear us now?
Yep, they gave thumbs up.
You can hear us now, and they're both on mute. Okay.
Yes. Yeah.
Awesome.
Susan, can you hear me?
Yes, I can hear you perfectly, Alex. Thank you.
Okay. At this time, fellow board members, have you all had a chance to review the director's decisions, violation resume, warning letters, and inactive status letters? Yes. Do we have a motion on said items?
I'll make a motion to approve the director's decisions, violations, warning letters, and inactive status letters.
Okay, we have a motion. Do we have a second?
I'll second.
Thank you, Susan. We have a motion and a second. All in favor?
Aye.
Aye. Motion carries. At this time, we'll hand it over to the director for our monthly ABC administrative updates.
Yes, and I'm just going to do a quick update because we do have a hearing and lots of people here. So, moving right along, we have been busy as we kind of always are, but we are excited to have Stacy DeJarnette appointed as our newest ABC board member. She's on screen if everyone wants to wave. Hopefully we will see her soon next month, and we'll kind of get rolling back with a 5-person board, which I'm very excited about. Perfect. Seminars. We are back on the first Friday of the month for seminar. September was busy. We had 94 people. So our attorneys do a morning and an afternoon session, and that's the total. So it was a very busy day. Next one's October 3rd. Okay, on the ABC side of things, we have 31 offers accepted covering 44 violations and 2 warnings, right around $21,000. There is one more director's hearing scheduled out before October, but since the last board meeting that we were here, we haven't had any. On the marijuana side of things, they have also been busy. 37 offers accepted covering 316 violations and 18 warnings. They offered fines in the amount of $63,000, and we have not had any directors' hearings scheduled out for the next month. In the news, people are not drinking as much. We keep seeing these headlines, and I think it's got to do with the other options. We're seeing lots of different kinds of drinks. Obviously, here in Arkansas, we are not seeing hemp beverages anymore. Enforcement has kind of taken care of some of that for us, which is great. We very much thank our agents for going out and doing courtesy visits and making sure people were aware of that change in the law. But there's lots of other non-alcoholic beverages that are served at bars right alongside beer. So just a trend that I think we could all be aware of. However, in Arkansas, with dry counties, we're actually seeing permit numbers go up as our legislature starts lessening some of the restrictions on those permits. So even though maybe nationwide people are drinking less, in Arkansas, we're actually seeing more permits. And marijuana sales. People are spending money in dispensaries. We are up about $10 million from where we were last year. Sales tax is right around $20 million for the year. And that might be all I've got. So we're ready for the hearing when you guys are.
Thank you, Christy. At this time, we'd like to move forward with our one hearing of the day involving Stacy Morrison at Friendship 67 Liquor located at 3000 Malvern Road in Arkadelphia, a retail liquor and retail beer off-premise replacement application, appeal of the director's decision by opposition. Do we want to start with swearing?
Yes, if you'll swear in anyone who's planning on testifying today. And I believe we do have lots of people here, except for those who haven't done an administrative hearing before. You go first. In that case, this is Mr. Jatt and his counsel. And then Keisha will go for the state. And if there are any other parties that need to address the board, y'all can do so at that time.
So if you're a part of any of those parties today and you plan to give testimony, if you could please stand and raise your right hand at this time. Do you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Forgot about us.
So this time I don't see his name here.
Is there an attorney here for Mr. Jatt?
James Lucas Graham for Mr. Jatt.
And would you please introduce your client to the board, and then you can go ahead and sit down at that table right there and start rolling.
Khalid Jatt is my client.
that?
As I said, my name is James Lucas Graham. And I had
You can
some
go sit behind.
packets kind of breaking down our, arguments and positions for the board. Can I just
Have you shown them to Keisha?
I don't believe so.
She'll need to take a look at those before they.
There's 3 separate ones on the 3 separate.
Yeah, you take a seat. Can you, while he's looking at that, could you spell your name for the record?
Khalid. My last name is Jatt.
Okay, thank you. And how do you say your last name? So I say it correctly.
Jatt.
Mr. Jatt? Okay. Thank you.
And if you'll just give counsel a few minutes to review, if she has an objection, she'll make it.
Okay. And if she doesn't have an objection, this would be admitted as
Respondents exhibit packet, or if they're in separate packets, respondents exhibit 1, 2, 3. And do you have enough copies for the board members? Now, you do understand we have a board member online today. So I don't know exactly how you want to handle that as far as your exhibit packet.
I don't.
Can it be emailed
Where
to?
you get one to her?
Do you have a digital copy that you could email to her?
Yes, after that.
Could you email it right now, maybe?
I don't think I didn't bring my laptop with.
Well, if I could speak,
You don't need
okay, that's not on. I would object to these exhibits, all of them. The basis being that the opposition letter that was submitted by Mr. Jatt's attorney addressed two issues. We could get into those in more detail, but the two issues were that this was the wrong application type that Mr. Morrison submitted, and that the ABC director should wait to make a decision about Mr. Morrison's application until their lawsuit has completed. So these issues about public convenience, public advantage, population, census numbers, the number of retail permits was never brought to the board. They did briefly mention some of these items, but it was after the director had already made a decision to grant Mr. Morrison a retail liquor permit. And in the Code of Arkansas rules, it's 3 car 1-203. Those factors about public convenience that are here in these exhibits have to be brought before the director makes a decision on an application. In other words, this is late, so we shouldn't address it at all.
You guys make the ruling on that if you have a response. Yes.
Sure.
As I understand it, the only things the board can consider are those public convenience and diversity and other factors that are contained in those exhibits. And if we're barred from addressing those, I don't see why we even need to have a hearing today, because the issues or the objections that were originally raised wouldn't qualify for, don't serve as, I guess, valid objections.
I guess the challenge that I have from our side is there's a lot of kind of different pieces with this case, and we've not really heard anything on it. So I know this is breaking protocol a little bit, but in order to even really understand, like, is there any type of like cliff note, high level?
So
like,
what I
overview?
believe we can do, and I will let Cameron correct me if I'm wrong because he serves as a hearing officer in some other capacities. I believe we could do opening statements first, and we could let both counsel kind of give you a preview, and then you could rule on the admissibility of the exhibit packet once we get to questioning from the respondent's attorney.
Yeah, that'd be fine.
Is that
Just
okay?
because I feel like we're flying a little blind on.
I understand it makes it kind of complicated.
Yeah, if I could piggyback on this, so if you guys are gonna do opening statements, I'm a new board member, you guys have really got to lay out what the case is here, okay? So, speak very plainly.
So do you want to wait on admitting the exhibits?
Yes, yeah, let's just hold it
We'll
for a
take
minute.
that up.
In my opening, I have to address these factors.
You can give a summary of your defense in your opening. Yes, sir.
Good morning, board. As I indicated earlier, I represent Clee Chad and I guess the 68 Hot Spring County residents who signed the petition in opposition of the Friendship 67 liquor permit. They are objecting to the issuance of this permit on three main factors. The first being that the permit would not promote public convenience and that the area is already adequately served by existing establishments. Hot Spring County, if you're not familiar, it's kind of shaped like a key. Friendship, Arkansas is in the southern portion, right where the handle of the key would meet the stem of the key. It's a kind of a remote area. The closest towns to Friendship are Midway, Donaldson, and Brown Springs. Those towns, I think, have a combined population of about 893 people. There are 24 total townships in Hot Spring County, and other than those four, the other 20 have closer and more convenient liquor store options available to them. In the western side of the county, you have Bonnerdale Liquor and Lake DeGray Liquor Store, DeGray Liquor Store. In the central part of the county, you have Cross Ties and Twisted Spur Liquor. And as you get up northern portions, you have Bud's Liquor that services the areas of Jones Mill and Magnet Cove. And then when you get down to the southwestern portion, Pop's Place in Leola, Arkansas is the closest liquor store. So the liquor store going into Friendship, Arkansas would only be convenient or beneficial for those 4 small townships containing 1,000 people. There are 33,000 plus people in Hot Spring County, so that's only 2.67% of the population that would not have a convenient option. Also, Friendship, Arkansas is only 7.3 miles from DeGray Liquor, which is in Arkadelphia, and it is 7.9 miles from Celebration Fine Wine and Spirits in Caddo Valley. So the people of Friendship, Arkansas are already less than a 10-minute drive from obtaining beverages and services. Friendship, Arkansas, the second point, is in a very remote area that's sparsely populated, and it is no police presence whatsoever. Friendship Police Department was closed down by unanimous vote of the Township Council in 2012 and has remained permanently closed ever since. Donaldson, Midway, and Brown Springs also do not have police departments. Even if they did, they wouldn't have jurisdiction to respond in Friendship. And the closest agency that has jurisdiction to respond to Friendship would be the Hot Spring County Sheriff's Department, which is 15.5 miles away in Malvern, Arkansas. So any calls or service calls that would be made to Friendship would require a pretty hefty response time. We have a former sheriff's deputy here who can speak more to that. Troop K in Hot Springs would be the next closest place, Arkansas State Police, the jurisdiction to patrol or service Friendship, and that is 31.5 miles away. As I said before, those 4 towns only have 893 people, and the population density between them ranges from 2 people per square mile up to 473 people in Donaldson. So that would be the second reason that we would oppose the granting of this application. And then the last would be the diversity of ownership requirement. Currently, there are 3 active liquor permits in Hudson County, one that is up for consideration. All 3 are owned by Caucasians. The 4th is being applied for by Stacy Morrison, who is the husband of one of the other owners, the owner of Cross Tie Liquor. So if you granted this application, one married couple would own 50% of the liquor permits in the county. Also, I believe the next applicant in line behind Mr. Morrison is of Indian descent. So if that were to go back in the pool, then a minority owner would potentially be able to get that license, thus increasing the diversity of ownership in the county of liquor permits. And those are the reasons we are opposing this liquor license.
Thank you.
Okay, board. I'm going to give the real story here in a second, but I would agree with what Mr. Graham stated initially, that the only thing you can consider are the factors for public convenience and advantage, and they have to be brought timely. So once again, if you don't bring those in the proper time frame, we can't hear something retroactively. I also believe that the diversity section was repealed this session, but we'll check on that and get back to you. So I do want to keep my objection as to these exhibits and give you some background. This hearing is a little bit unusual. Normally we're here when an ABC agent goes out to do, say, a routine inspection at a permitted premises, right? There's a sale to a minor, there's a disturbance, something like that. And there's a violation that's issued, and oftentimes that permittee will protest that. And that's usually why we have a hearing. This is a little bit different. This is an opposition hearing. So this means that someone has challenged Director Bjornson's decision to issue a permit. And I'll explain to you a little bit later why it's not quite the issuance of a new permit. This was really a permit that was already in existence. So specifically, Mr. Khalid Jat opposed Director Bjornson granting a permit to Mr. Stacy Morrison. Now, Mr. Jat and Mr. Morrison are complete strangers. They don't know each other, but they both know a woman named Katie Tatum. Now, Katie's not here today, I don't believe, but the backstory of this is kind of like a bad breakup. So it's Hot Spring County. We have to go back to 2022. Hot Spring County voted to go wet. This allowed retail liquor permits. So retail liquor stores could now come into the area where they were not able to before. So a lottery is held when that happens. And Brandy was actually present at that lottery. And she'll explain to you how the lottery process actually works. But Mr. Jatt submitted an application for one of the retail liquor permits that was going to be available through the lottery. Now, according to public records filed in Hot Spring County Circuit Court in his lawsuit, he also, quote, devised a business plan whereby he convinced Katie Tatum, who used to work for him, Katie was his employee at one of his gas stations, to submit an application as well. The idea being that he would take over that permit later. Okay, so there's several problems with that, right? Ethically, and your gut kind of tells you that there's something off about that. It's a violation of statute. It's a violation of rule to use a straw man in a lottery. Okay, everybody who participates in the lottery is supposed to put their name into the drawing once. Okay, and all the information in ABC applications and forms is given under oath. So we're at the lottery. You've got Mr. Jatt's application in the lottery, and you've got the application that Mr. Jatt filled out and asked Katie to put her name on. Well, Mr. Jatt's application was not drawn that day, but Katie's was. So they continue to work together. Katie's name is on that permit. In fact, it's the only name on that permit. She applied as a sole proprietorship. There was no LLC. Nobody else was listed on that application as having any sort of interest in the permit. So ABC knows that this is Katie Tatum's permit. Now you can imagine when, let's fast forward 3 years later to June of this year, because remember, all this started in 2022. Katie Tatum comes to the 4th floor of this building and puts the permit on inactive status. And Mr. Jatt was not a happy camper. But it's 3 years later, and her name is still on the permit. She has all the liability. It's her responsibility, and she had every right to put the permit on inactive. She could have burned the permit if she wanted. Yes, sir.
Was there a active store in that 3-year period of time using the permit?
There was in 2024 in August, the permit was issued because it takes a little bit of time from lottery, right? Most people who enter the lottery, sometimes they don't have a brick and mortar at all. They have a piece of land that they are going to develop in hopes that they get the permit, right? So there's some lag time there. So 2022 lottery happens. There's some time it takes to get that store up and running. And Mr. Jatt got that building and that space up and running, and Katie worked there. So there was a store.
In 2024 it opened.
I believe so, because that's when the permit was actually issued, actually physically given to Katie Tatum in her name.
When she put the license on inactive status in 2025, earlier this year, that closed the store.
Yes, effectively that's what it did. Yeah,
Okay.
that was the practical effect of putting it on inactive. So any permit type that we have, once it's on inactive, that means you're just going to shut down. It can be for, a period of time. It could be forever until you know what you're going to do next. And keep in mind, we don't know about this deal or partnership that Katie Tatum had with Mr. Jatt. We're not privy to any of that. And we don't get involved in our permittees' business matters. So she put it on inactive, and she also came to the office with Mr. Stacy Morrison, and she filled out what's called a replacement notice. Now, a replacement notice will name someone to take over your permit, and at that same time, that person has to submit their own replacement application, as it's called. And Brandy will explain what the replacement process is and that it differs from a transfer. But more importantly, once a replacement is initiated, it cannot be rescinded under our rules. The Code of Arkansas rules says once we accept that application, the replacement application and replacement notice, the process has to finish out. Okay? So that is when Mr. Jatt, who's unhappy with this development, submits a written opposition asking Director Bjornson not to grant Mr. Morrison the permit. Okay, Director Bjornson and you all were to meet on July 16th for a board meeting. That is when Mr. Morrison's application was to be approved. This opposition came in at 3:43 p.m. on July 15th. That opposition letter did not mention factors about public convenience and advantage, police presence, population, availability, nothing. What it mentioned was that the wrong application had been done, that Mr. Morrison should have done a transfer. That's not what should have happened. A transfer is when you have a permit, you're operating your business, you want to keep operating your business, but you're going to transfer across the street to a different location. It's not what happened here. When we get the replacement notice and replacement application, it's a different scenario. So again, the opposition letter that came in at the final hour at 3:43 p.m. on July 15th talked about it being the wrong application. And secondly, Director Bjornson should wait to make a decision until their lawsuit works its way through the circuit court. Their lawsuit with 5 different named parties. Okay. Director Bjornson considered that, and the next day at the board meeting, she had every right to approve Mr. Morrison's application, and that's what she did. So after that board meeting, Mr. Jatt appeals, raising different objections, okay? And those objections are the public convenience and advantage issues that you heard about, but at that point, it's too late. The CAR says those have to be raised before Director Bjornson makes her decision, before that July 16th board meeting. So that is why we are focusing on the July 14th, 2025 opposition letter that talks about the wrong application and that we should wait on the lawsuit. So in short, Mr. Jatt's opposition wasn't sufficient. His appeal isn't timely. That's why I agree that you can only talk about factors with public convenience and advantage, but unfortunately, they didn't raise that issue timely, and so we can't discuss it. The bottom line is this is about Mr. Jatt's falling out with a business partner. Again, we don't have any information about that. We're not privy to that. But he certainly didn't oppose a retail liquor permit in this county when he was involved with it to some degree as a partner or whatever he was. But now suddenly he opposes a liquor store in that county, and it's not an additional liquor store. Again, it's almost like the permit that Katie Tatum had is just moved over to Mr. Morrison. So we don't have an additional liquor store. So this is really just, like I said, a kind of a bad breakup between business partners, and it's disguised as opposition from concerned members of the community.
And point of clarity, you were saying Mr. Morrison, but it's really Miss Morrison.
It's Mr. Stacy Morrison is a gentleman, and he's here. Yes.
Oh, I thought there was something said earlier that his wife and
She runs Cross Ties and owns a liquor permit in Malvern. It's
Okay.
different.
I don't believe that they're married,
They're not married. Oh,
so
not married.
they're partners. So.
We're partners.
The objection letter, did it come in on 7:14 or 7:15 at 3:45?
We can get into the specifics of the evidence once we actually get into the hearing. I don't want y'all to get too hung up. The summary is just an opening summary. And also, please, nobody speak from the gallery unless you're called to the table to speak. Thank you.
Okay. It's very helpful on both sides, giving a little bit of an intro. This is, as mentioned, this is not a normal type of proceeding that comes in front of us, and we have some new faces in here. I think in the time I've been here, we've maybe had 1 or 2 of these also. So,
And if you guys need to kind of deliberate and discuss on any evidence, you can also still allow any testimony and questioning, and you could approach each exhibit individually, if you want to. So there may be one that Keisha and you can talk about that the board would let in, but another that they might not. So that's up to you guys.
yeah, I kind of turn to the board if there's any other questions or thoughts before making a ruling on this evidence, and then we can go back into letting them do the rest of their opening. So any thoughts, comments on those?
Right. Let me just make sure I got this right and stop me if I'm asking something I can't. So did the letter arrive on 7:15?
It arrived the day before the board hearing.
So that was 7:15 then, the day before, and that was late.
Correct.
Do you agree that it was late?
The initial objection,
Let me correct. The opposition letter did arrive in time. Okay. The later appeal, based on public convenience and advantage, the factors that they're talking about today, that was late. I'm sorry, I misspoke. So that that letter came.
on August the 14th, I believe. But that was within 15 days of getting the notice of decision and the indication we had 15 days to lodge an appeal.
But the CAR says that you have to bring opposition based on public convenience and advantage before the director makes a decision on the permit. So they could have brought those issues, but it would have had to have been before Director Bjornson made her decision. And I can show you that.
So we made the decision was made on August the 17th, is that right? At our board meeting on August the 17th?
So July.
No,
July,
it's
I'm
your
sorry.
July meeting where the decision was made.
And you brought your opposition for that after the July meeting?
I believe that Mr. Jott submitted the first letter himself. And I believe he submitted the second letter himself as well. I didn't get involved until.
If I can clarify, I think there's a difference between procedurally late and legally late. I think Keisha is saying that the arguments that he was making, he should have made before I made the decision. And I believe what other counsel is saying is that procedurally, he did follow the appropriate time to file an appeal. His first appeal just didn't state any of the factors. So that's Keisha's point, and that's other counsel's.
All right, so just give me a minute. I'm slow, but I'm worth the wait. I believe there are two criteria that you've got to meet in order to be considered on time. One is you've got a 15-day window from a notice. You were within that 15-day window, but you were after the July 17th decision.
That's not really it. It's you can.
I'm Drew Cousins, another attorney for ABC. So when you have opposition to a permit that has been put in, that permit information goes on they have a sign that goes on their building. They have to put it in the newspaper to give public notice that they have put in an application to the ABC. So our rules state if you have opposition to a permit that is to be heard by the director and the board, you must, a pending application, you must write to us in a certain format. They did that the day before the board. That opposition letter, however, only mentioned the lawsuit and that this was the wrong type of application. Next day, board director approves this, board approves the resume, and then a few days later, after they've been given notice that they have 15 days to appeal, they send in a petition mentioning these public convenience and advantage factors. But that was after the application had been approved. The pending application part of our rules means that they should have sent in whatever objection they had while it was still pending. They sent in that second objection letter while they had time to appeal the decision that had already been made.
Gotcha.
So hope that clears up
Very
procedurally.
much so. Thank you.
Yeah, complicated rules we've got around here.
So public advantage and public convenience should have brought up prior to the vote.
In the original
objection.
that was like right before the meeting.
Right.
Those are factors that the director is to consider when making her decision on whether or not to approve.
And
Do you agree with that?
I mean,
Do you agree that
the
public?
principle is you're reviewing the director's decision. So, her decision was based on what was in front of her. If she didn't have certain arguments in front of her to consider, then.
Okay, now I'm just asking this though, but you both agree that we can only consider public convenience and public advantage today, right?
Correct.
But in order for you to object those, you should have objected those prior to July 17th. Is that correct?
That is ABC's position.
Okay.
But I would agree if you guys affirm that, procedurally, this hearing is.
you can You can always listen to whatever evidence you want. Just kind of as an aside, I've been in front of judges who are frugal in what evidence they let in. I've been in front of others who are like, let it all in and I'll make my decision at the end. So it's kind of up to y'all. You've heard from both sides. I think you know this about the substance of what his exhibits are going to be about and can probably guess the substance of what Keisha's going to talk about. If you want to hear all of it, that's up to you guys.
Yeah, I mean, I'll let the other board chime in before making an official ruling, but I mean, I think that by the letter of the law, that evidence should not be admitted in, but we've at least heard what it's about. So like, to some degree, it helps paint the picture of where y'all are coming from. But from my position, I don't think it meets the criteria to be admitted, but I'm open to other thoughts and ideas on that.
Yeah, I mean, I agree too. I think both sides have agreed that we can only hear things of public convenience and public advantage, and that those should have been brought up before July the 17th. I think everybody agrees to that. So,
Okay. So, Susan, do you have any comments?
No, that'll seem back.
Okay. Well, with that being said, at this time we would not accept the respondents' exhibits 1, 2, and 3 into evidence at this time.
You are still free, however, to discuss whatever needed with your client in front of the board.
Again, we can't touch on the public convenience and those factors in his evidence regarding them. There's no basis to overturn the director's decision, and we would withdraw our objection.
Withdraw your objection to the decision because, I mean, we're still set here for a hearing today. And so if you are not wanting to proceed with a hearing, then that is fine. But if you are still wanting to proceed with a hearing, I do think Keisha should be afforded the right to explain to the board why they're all here today.
No, I don't see it. Like I said, if the finding is we would be limited to the arguments that were presented prior to the director's decision, those arguments were not a valid basis to overturn the director's decision, and I don't see a reason to waste everybody's time.
The board is still going to have to do an order, though, and we are going to have to put some sort of factual basis about what happened today, a conclusion of law. So if you still want to hear our side of things, that might make it easier for you to make an order.
Mr. Graham, you can still submit evidence through testimony, be it through Mr. Jatt or any of your other witnesses. They could talk about anything else to kind of argue your case. It's just procedurally that evidence, that you brought in would need to, we've kind of labored it to death on how it should have come in.
Sure.
But you still have the opportunity afforded to you all to bring anything forward at this time through, closing statements, through testimony, anything like that that you'd like. So, and if you wanted to take a second to confer with your client before.
You want to call witnesses? We can call witnesses, that's fine.
Okay. Do you guys want to recess before you get to the questions portion of the hearing? I know it's kind of been a slow start, or do you want to just roll right in?
I think I'm ready to keep rolling.
All right.
Unless you all need.
Oh, no.
And sir, can I please admit my exhibits? I have exhibits 1 through 13 that I'd like to admit.
Okay. And those are in our packet.
They are in the packet. Mr. Graham has it in his packet. Mr. Jansky, who's here with Mr. Morrison, also has it in his packet.
And so you need to have us accept exhibits 1 through 13 on behalf of the state.
Yes, sir.
Okay, that's so granted.
Thank you.
So you can proceed with the yes.
I would call Jeremy Milner.
We have you can sit right there. If you want to move that little tripod to the tail, we're not using that. Give you a little bit of space. Yeah, go ahead.
Mr. Milner, where do you live?
I currently live in Malvern, Arkansas.
And how long have you lived in Hot Spring County?
In Hot Spring County, I've lived there for about 15 years.
Do you have other family that resides in Hot Spring County?
Yes, I do.
And what locations do you have family?
I have family in Malvern, Donaldson, Joanne, and Friendship.
And did you used to work in law enforcement?
Yes, I do.
Where did you work?
I worked with the Hot Spring County Sheriff's Department at the jail.
And being a resident of Hot Springs and for a long time, are you familiar with the Friendship area and the location the liquor store is proposed to be placed in?
Yes, I
And having previously worked for the Hot Spring County Sheriff's Department, are you aware of any law enforcement departments or agencies that are close to the Friendship area?
not that I'm aware of. Closest one is Hot Spring County.
Hot Spring County Sheriff's Department. In your time at Hot Springs County Sheriff's Department, did you make trips from the Sheriff's Department out to Friendship, Arkansas?
Towards that area, yes, I've had to make transport multiple times.
Do you have any idea how long it takes to get from the Sheriff's Department in Malvern out to Friendship?
Back when I worked there, they had about one officer traveling approximately a 20-mile radius. It would take them anywhere from 25 to 30 minutes to make an impact.
So they just only have one officer assigned to the area around Friendship?
Yes.
Are you opposed to a liquor store going into Friendship, Arkansas?
Yes, I am.
And why are you opposed to a liquor store going into Friendship, Arkansas?
In such a small town like that, you've got a lot of kids that play on the street. Before you put a liquor store there, that's going to increase the drunk driving out there. And if it takes an officer 25 to 30 minutes to get on the scene, that's a situation we just need to avoid.
Are you familiar with what other liquor store options are close or nearby Friendship?
Caddo Valley and Arkadelphia, I believe.
And are there any other reasons that you'd like the board to know why they should not approve a liquor store going into Friendship, Arkansas?
Just the safety and convenience of it.
Our best friends.
Mr. Milner, do you know what the population of Hot Spring County is?
I do not off the top of my head.
Do you believe that liquor stores should only be in highly populated areas?
In my personal opinion, yes.
Okay, so people in rural areas, they don't need convenience stores near them to shop at. They need to go into town.
Convenience stores and liquor stores are completely different.
No, I mean convenient. Do they have the right to have an option available to them?
Absolutely.
Okay. I'm going to show you what I am going to offer as government exhibit 14, but hasn't been admitted yet. This is a petition to object the approval of retail liquor store Friendship 67 Liquor LLC for applicant Stacy Morrison. Is that your signature on page 3 of this document?
Yes, it is.
Okay. Where did you sign this petition at? Where were you?
I do not recall.
Weren't you in a liquor store? 270 Beer, Rum, and Spirits?
No, I've never worked.
No. Were you there when you signed this petition? Were you on the street?
I've never actually been inside that liquor store.
Do you recall where you were when you signed that petition?
I do not.
Okay. Could you have been in a liquor store when you signed it?
I don't drink. I'm epileptic. I have no business being in a liquor store.
Okay.
Where is his signature on this?
Which page was
Page
it?
3.
That would have been page 3. It's at the top.
Would you like
About
for us
third
to
down.
admit this as state's evidence exhibit 14 at this time?
I would.
So granted.
And this was signed at 7/18? 7/18, is that right?
That's the date. Yes.
Okay, and you don't remember where you signed something on 7/18?
I do not recall that.
Okay.
Okay.
Did you read the petition?
I don't remember. Honestly.
Did you notice that in the beginning of the petition, in the box at the top, it says that Friendship Liquor was located in Donaldson, Arkansas?
I do.
Okay. And do you know that Friendship Liquor is actually going to be in Arkadelphia, Arkansas, which is 25 miles away?
Yes.
Okay.
But
So
but it's not gonna be in, Arkadelphia is Clark County,
Is this an objection?
sorry. No, I'll withdraw.
no further questions.
Do you two know each other in any way, shape, or form?
Me and the lawyer,
You and Mr. Jack?
oh, I'm sorry, yes. I've worked for him the past year.
Okay. You still employed by him?
Yes.
Are you aware that Mr. Japp was connected to a previous liquor store that was connected to this whole thing that brought us in here today?
I know that he owns that 270 Beer Run and Stripes. I didn't know that it's connected. What do you mean connected?
Well, from what we heard earlier today, Mr. Jatt had an affiliation with another employee of him, similar to you, that had a liquor store that was open for about a year in Hot Springs County. Were you aware of that?
I've heard people talking about it, but I don't consider that factual evidence.
Right. That your employer
Yeah.
had a connection to that. Did you object? Would you have objected in that same scenario to that one being open?
I would have guessed.
So if the scenario was to be the situation that we were not to grant this transfer and Mr. Jack was to, your employer was to get that liquor store back in some capacity, you're saying on the record that you would be objecting to your boss
I would
on
be
that,
objecting, yes.
and you'd be here in the same capacity.
Mhm.
Okay. Any other questions on our side? Okay. And this time we don't have any other questions. You may be seated. Thank you.
Sharon Barkley. Actually,
It would be your questions first.
please state your full name.
Sharon Barkley
Where do you reside, Ms. Barkley?
on Highway 67.
And how far from Friendship or, the area that the liquor store is going in, how far do you reside from?
Approximately about 15 miles.
15 miles?
15, yes.
And how long have you resided in Hot Spring County?
20 something years.
And what do you do for a living?
I work for Walmart.
And are you opposed to a liquor store going into the Friendship area?
Yes.
And why are you opposed?
Friendship area, there's a lot of elderly people that live there. And honestly, I don't think that it should be there. Because number one, safety for them as well, because I mean, they drive out on the streets and stuff. And there's several kids that live there too.
Are you in the area of Donaldson and Friendship regularly?
I'd say probably at least once a week, probably, if not more.
Over the last 22 years?
Yes. Well, probably more than that, over the 22 years, I guess.
Do you often see law enforcement, police officers, sheriff's deputies in that Friendship and Donaldson area?
No, sorry.
Do you have concerns about that as far as the liquor store going?
I do, yes.
Do you drink?
No.
And are you opposed in general to liquor stores being open in Hot Spring County?
In my opinion, I mean, it's their preference. If they want to drink, that's their preference.
I'll pass the witness.
Ma'am, did you sign the petition?
No.
Okay. And the proposed location of Friendship Liquors, 3000 Malvern Road in Arkadelphia, isn't that a rural area?
Mhm.
So is there a daycare around?
Not to my knowledge.
There's no school around?
Probably about Donaldson, so I'd say probably about 5 miles maybe.
You said it's
Beverage.
Donaldson?
Yeah.
Is that because you read that on the petition? Because
No, I
the-
know there's a school there.
Okay. Well, the address is 3000 Melvin Road in Arkadelphia. Why didn't you write an opposition letter to the board before this permit was approved?
I didn't know I could.
How did you find out about this hearing?
Lawyer.
He called you?
No. Well, I mean, yeah, he called me, yes.
Do you know Mr. Jett?
I do.
Did
He's a friend of
you
mine.
do you work for him?
No.
Have you ever
Work for
worked for
Walmart.
him?
No.
Okay. How did you befriend him?
Just, my ex-husband done work for him. That's how I know him.
What kind of work did your husband do?
Like carpenter work.
Have you ever been to 270 Beer Run and Spirits liquor store?
Not that I recall, no.
Did you know that that's Mr. Jett's liquor store?
I did.
Was he was involved in that
Mhm.
store? Okay. Did you know Katie Tatum?
Mm-hmm.
How did you know Katie?
Just through work, because she worked at Shell too as well, and I'd go in there and talk to her and stuff like that. I mean, everybody talks to their people that when they go in convenience store.
Did you know that the number of retail liquor permits is based on the population of the county?
I did not. I just knew that there was, 4 issued for Hot Spring County. When it became wet, that's what they were saying. I just hearsay. I didn't hear anything like that.
And there'd still be 4 retail liquor stores in Hot Spring County, right?
Mm-hmm.
No further questions.
Point of clarity on our side, so the 270 Beer Run Spirit is still active and running, and that's separate. Is that the one that Kelly?
Miss Katie Tatum's permit was hung on the wall at 270 Beer Run and Spirit, and when she put that permit on inactive, that location was no longer allowed to sell alcohol.
And then Mr. Jett has no other known affiliations with any other liquor stores.
Within
the other three permitted and watched at Hot Springs County.
Not that I'm aware of. He does have, I believe, 2 retail beer permits for convenience stores that he owns. The Shell being one of them.
Yeah, she mentioned. What's the name of that station, or do we know?
I would have to ask Mr. Jack.
Okay, so when we talk about the 270 Beer Run Spirit in questioning, that's the one that was previously open, that closed, that went in inactive status, and brought us here in today with the Morrisons on the new location. Do we know the distance between those two, locations?
Yes, 270 Beer Run and Spirits is about 25 minutes away from Mr. Stacy Morrison's proposed site. So about
minutes or miles?
Minutes. Over 10. Oh, yeah, it's almost 20 miles. I would agree with that.
Okay. Just wanted to have some kind of clarity there.
Yeah.
And how do you say your last name?
Barclay.
Barkley. Ms. Barkley, did you ever go to the 270 Beer Run Spirit store? But you are aware of that location?
Yes.
Would you say, I'm not from the Hot Springs County area, would you say the makeup of the areas are similar both in rural areas of the county, would you say?
Yeah, there's just friendships, just like a small town. Yeah.
And so based on what you're saying here today, are there kids, elderly people that live around the 270 Beer Run?
No. I mean,
no children or old.
There's like a bank right beside it, and as far as like right there at it, no.
Within 2 miles, I believe is what you said the distance was. People either
2 miles, there's like a residency like right in front, like one on, what is that, like 51. But I think that they're like younger, middle aged. They're not like elderly.
Okay. And there's not children that you're aware of that live in that?
Not that I'm aware of.
Okay. I don't have any other questions. Does anyone else on the board?
Ms. Barkley, would it would you be here opposing, would it be your testimony under oath that you would be here opposing any liquor store at this location?
In this county?
At this location, at the proposed location that you're objecting to today?
Like I said earlier, I mean, that's people's discretion if they want to drink or whatever. I'm not opposed of it, no. But when it comes to elderly people, then like living close by, then yes, I do. I mean, I know that y'all probably are aware of, elderly people, they don't know how to drive, I guess you could say, not that perspective, but if you have a liquor store right there and you've got people that's drinking and driving, because they all do, not all do, but some do, somebody could be pulling out of their driveway and then, they get either hit or absolutely, get killed. That could happen anywhere, I do understand that. But there's more elderly people in that town than it is, and I'm pretty sure where Cross Ties is at, don't know if there's any elderly. There is a hospital right beside it, but as far as that, as elderly people with children, I don't know.
Okay. Thank you.
I do have a couple of follow-up questions. You do realize that people can't drink inside of a liquor store, correct?
Yeah.
Okay.
Yeah.
So nobody's drinking on the premise.
No, I
of a
didn't
liquor
say
store.
drinking on the premises. I said they do drink and drive.
So they
And
would,
they could be, drinking already and then go into one, is what I'm saying.
and they could be drinking already and going into a bank, right?
Mm-hmm.
And drinking already and going into a school,
Mm-hmm.
drinking already and going into a daycare.
Mm-hmm.
So people could just be drinking everywhere in the world
Right.
and driving.
Yeah.
Okay. You do realize there's on-premise locations that serve alcohol on the premises.
Yes, I do.
No further questions.
Any follow-ups on your side?
No,
Thank you, ma'am, for your time.
we have no further business.
Okay.
Would you be okay with a 5-minute break
Yeah,
before
sure.
the state side gets started?
That's really fine.
Okay.
Thank you all for your time so far and being patient with this.
Thank you. I mostly had to run to the bathroom.
No, you're good.
I was hoping we.
Should I remove this? This is where.
Hold on.
Yeah. But
That was my overlay.
state. You're ready to proceed whenever
Yes, sir.
you're ready.
And can we just do a double check since we took a recess? Susan and Stacy, can you still hear us and see some of us?
They might not be back yet because their cameras are still off.
We do just want to make sure that we don't start without Susan.
Here.
All good? All good? You're a little loud in here, Susan. That's why we all laugh when we're sorry. Okay, if y'all are ready, I think we can be ready.
Yes. Please proceed, state this time.
Okay, at this time, I'll call my first witness, Randy.
And for the record, who's coming on?
Can you state your name for us, please? Randy Ward.
Hello, Brandy.
And what is your position here at ABC?
I am the office manager.
And do you like your job here? No, I'm kidding.
You are under oath.
I am just going to get these exhibits a little closer to us so we can share this binder and make it a little bit easier. So we can just get organized. All of these. Okay. So can you tell us a little bit about the lottery? So in 2022, Hot Spring County went wet, and that meant they were eligible to have retail liquor stores. Is that correct?
Correct.
Okay. Do you recall how many retail liquor permits were available at that time?
There was 4 available.
Okay. And ABC conducted a lottery for those 4 permits, right?
Correct. And in front of the board, we go and we do a 2 drawing lottery. First draw is your number in line for the actual retail liquor store. So I would come up, I draw a number that would put me in line. If I was number 1 in the first drawing, I could go draw an envelope in the next one and be number 7. So, which would take me out of the running for this one because there were only 4.
Okay. And how did we get to the number 4?
It is based on population. It's 1 liquor store for every 7,500 people.
Okay. So you just described how that worked. Thank you for that. Now, did Mr. Jatt put in an application into that drawing?
Yes,
Do you remember if Katie Tatum put an application into that drawing?
she did.
And you were present that day?
Yes.
Okay. Are people allowed to put in as many applications as they want, or is there a limit?
No, there is 1 per person per location.
Okay. And that's based on statute, correct?
Correct.
Now, there are some folks out there with more than 1 retail liquor store, but that's because they're grandfathered in.
Correct.
Okay. So on Katie's application, she listed herself as a sole proprietorship. Isn't that correct?
Correct.
I'm going to draw your attention to Exhibit 1. This is the retail application of Katie Tatum, is it not?
Yes.
You've seen that before, right?
Yes. That's my handwriting up at the top.
Okay. So we're a couple pages into this exhibit, and we see your handwriting on the top left, and this is an application for a retail liquor permit.
Yes.
Now, Mr. Jatt is not listed on this application as a business partner, right?
Correct.
Okay. Now, also I want to draw your attention to Exhibit 10. This is Arkansas Code Annotated 3-4-209. And this statute is about the applications that people submit to ABC. And it says that they should be given under oath and that they shall list people who are interested in or will become interested in the business of any permittee for which the application is made. Is that what you see there in that statute?
Yes.
Okay. And so just to reiterate, there was nobody else listed on Katie Tatum's permit application.
No, just her.
Okay. Now, at the lottery that day, was Katie Tatum's application selected?
Yes.
Was Mr. Jatt's application selected?
No.
Okay. So eventually, Katie was granted that retail liquor permit in her name, and that was on August 7th, 2024, correct?
Yes, that's when we issued the permit.
Now, when there's a sole proprietor who holds a permit with ABC, like Katie Tatum, who is the named manager on the permit?
It would be the same.
Okay. So Katie Tatum's name is printed on that permit.
Correct.
Okay. Now, about 5 months or so passed, and Mr. Jatt attempted to submit a change of manager, not for one of his own alcohol permits, but for this Katie Tatum permit. Isn't that correct?
Correct.
Can you tell me a little bit about that? Like what happened
Yes.
with that?
So we mistakenly accepted a change of manager. Once it came to me to look over for board, I realized this is a sole proprietor. They can't do a change of manager. If it's a sole proprietor, that proprietor is on that permit. So I had Shakoria contact Mr. Jatt and let him know that he would need to do a replacement application if he's buying the business. So she gave him that after, I don't remember the date, sorry.
Oh, that's okay.
Okay.
That's okay. But Mr. Collegiate was told that he couldn't do a change of manager.
Correct.
Okay. And then at some point, Mr. Jatt brought in, and I'm going to draw your attention to, one moment, Exhibit 4. So the next thing that happens is Mr. Jatt brings in a replacement notice and a replacement application to our offices. Isn't that right?
Correct.
Okay, so the first page of this exhibit is a replacement notice, right?
Correct.
And Katie Tatum's name is on it. This document is supposed to be filled out by Katie, right?
Yes.
Okay, whose signature is on this document?
Don't know the first name, but last name Jatt.
Okay. So when you see that, what happens with this?
At that point, we did accept it, but then later found out that Katie did not sign the actual replacement notice, so we informed them that we were canceling this application because Katie did not sign the form.
Okay, so Mr. Jatt signed this document as if he were Katie, isn't that right?
Yes.
And he had Sylvia Keene notarize it. That's someone who's notarized other documents for him before, correct?
I'm not sure on that, but yes, she did notarize it. Sorry.
Okay. I will, one moment, please.
From a question on that perspective, is that not breaking everything of what a notary is supposed to do if it's saying that, it's got Katie Tatum's name up here at the top and then signing it that it's approved? Is that?
Yes, sir. That's a violation of the notary law. I'm a notary, and so is Mrs. Cousins. And then I would like to draw your attention to what has been admitted as the retail liquor application of Khalid Jatt. It's Exhibit 2. So this is actually the liquor application that Khalid entered into the lottery. Brady, I'm going to draw your attention to one of the pages towards the back of this. Do you see that same notary public's name on this document?
Yes.
Okay, so Sylvia R. Keene also notarized Khalid Jatt's lottery application.
Correct.
Okay.
The signatures didn't match.
I'm sorry, so the signatures didn't match on the replacement notice?
Yeah.
Right, okay.
So I believe Jatt's signature is not the one on that one.
Okay. This must be somebody else. H. Jatt is what it looks like to me. And we're looking at Exhibit 4 again. That's the replacement notice. And he also submitted in Exhibit 4, the next page, second page, is the beginning of an application that he was attempting to submit as well.
Correct.
And were you able to accept that?
We did accept it, but again, later found out that Katie did not sign the replacement notice.
And speaking of replacement applications and replacement notices, can you explain
what those are for.
Yes. So a replacement application is for people who are purchasing businesses. It allows them to work under the permit until it is actually transferred into the new ownership and new person.
Okay, and that is different from what we call a transfer at ABC, correct?
We have a transfer of location, which would just be moving this business to here, but not changing ownership or structure.
Okay, thank you for that. I also want to go back to Exhibit 2. So going back to the application that Mr. Khalid Jat submitted, actually, I want to go back to, one moment, the retail liquor application that Katie Tatum submitted at the lottery. That's Exhibit 1.
The application itself.
Okay. Back to, it's the third page of Exhibit 1. And you see Katie Tatum's name there. Now, she lists a business name as well, 270 Beer Run and Spirits.
Yes.
Okay. Isn't it true that 270 Beer Run and Spirits was not filed with the Arkansas Secretary of State until July of 2024? Well after the date of this application for the lottery. I'll show it to you.
Okay.
I'm going to show you what's been marked as Exhibit 3. This is an article of certificate of organization from the Arkansas Secretary of State. And it has 270 Beer Run and Spirits on it.
Yes.
And can you tell me what the file date is?
July 19th, 2024.
Okay, so going back to that Katie Tatum application for the lottery, that was submitted in what year?
23. 23, sorry.
So my point to that is that Beer Run and Spirits was not even in existence. Mr. Jat's LLC wasn't in existence at the time that Katie Tatum applied at the lottery, correct?
Correct.
Okay.
Can I ask a question? Is that a violation of the application process, I guess? That's why you're bringing this up?
Yes, it would be stating something in the application that's not true, first and foremost. And if Mr. Jat's position is that his LLC has some sort of interest or right to that permit, that LLC didn't exist at the time the permit was granted.
I mean, aren't we here today to review the director's decision to approve the?
Are you making an objection on relevance?
Yes.
You can
Mr.
rule on
Morrison's
an objection on
replacement
relevance.
application, I don't see what Mr. Jat's previous application process has to do with the review of the director's decision.
Well, go ahead.
And I would like to speak to that. That is because under 3 CAR 1301, people who give false information are actually subject to having all permits revoked. So we're here today and all of this is coming out. So it's a violation of statute, and it's also a violation of our rules to give false information and documents submitted to the ABC offices.
Again, I don't see how it's relevant to the review of the approval of Mr. Morrison's replacement.
I'd say it goes to credibility as well.
That did not provide.
But he did have sworn documents that were turned in. So, I mean,
He did not sign, Mr. Khalid Jet did not sign that replacement application. There's not his signature on that application.
Do you know who signed it?
Hamid Jet, I believe.
Do you know what the relationship is? Basically,
It's Mr. Jet's son.
Okay.
He was, I guess he ended up, was running, I guess, 270 Beer Running Spirit, managing running.
You know, my I know it's really loud when I speak, so I'll try to speak softly. Was the son authorized to sign on behalf of his father?
He was not signing on behalf of his father.
But they're in this LLC together. That's
I believe they're in this LLC together. You have a lawsuit that's been filed that says that they work together and that Hamid Jat and Khalid are intimately involved together in 270 Beer Run and Spirits.
Again, you
LLC.
said the LLC was not even in existence when the application was submitted. The LLC is, and again, Hamid Jad, I believe, is the president of 270 Beer Run and Spirits LLC, not Khalid Jad.
That was part of your objection, and the LLC was in existence when certain documents were filed with our office that should have been truthful but were not.
So the question for the board is the relevancy of the document in front of you to the discussion here today. Obviously, the state's
Or
position
this
is
whole line of questioning.
Got it. Okay. So do you have one something?
No, anyone else before
I don't, if I understand this correctly, right, really what matters today is whether or not there is a public convenience or a public advantage here.
Mhm.
We've already ruled that there's not. So I don't know that this changes the ruling. And in full disclosure, I don't know that it has to be allowed into evidence or that we have to, I guess we can.
Again, I don't know that we even need to continue because procedurally, I don't believe you guys could
If I
approve our
could-
objection if we wanted to.
we do. We have a hearing set. We have to make an order based on conclusions of law. So even if they got up and walked out of here today, we would still present our case to give
But
you
isn't it a
conclusions of law.
conclusion of law that we did not raise proper objections prior to the decision of the director, and therefore we do not have a valid basis to object to the decision?
It could be. Right now, we're ruling on relevance, so I just want to keep the hearing moving forward. Do you want us to wrap up this line of questioning and keep rolling?
Yeah.
Why don't we do that?
Thank you.
Yeah. So formally, objection, sustain, but let's wrap this up and move forward.
Okay. Keisha, if you'll move on.
Will do. Let's just skip ahead to when Katie Tatum came to the ABC office. When did she come into the office? Do you remember about the date? She was here with Mr. Morrison, correct?
Yes, the day that they submitted the replacement application that she signed in front of us.
Okay.
I'm bad with dates.
That's
Sorry.
okay. Stacy Morrison, and I'll draw your attention to Exhibit 5. That is the replacement application of Stacy Morrison, and that was submitted on June 9th, 2025. Is that the date that you see?
Yes.
Okay.
Yeah, we go by our timestamp, so yes.
Okay. So Stacy Morrison came in, he filled out a replacement application, and Katie Tatum filled out a replacement notice on that same day.
Correct.
Okay. And then drawing your attention to Exhibit 11, and that's Code of Arkansas Rule 3, Car 1-202, G3. And this is in the middle of this document. It is very difficult to find, board members. I tried to highlight it, but you're going to look over to page 19,
Which section is 11?
Exhibit 11,
It's towards the end of that group.
last page. And so big G and then 3, the CAR says that once your office accepts a replacement notice and application, that in no event shall the current permit holder, which would have been Katie Tatum, would be allowed to withdraw the replacement notice of authorization. Isn't that correct?
Correct.
So once it's accepted, it has to continue in the process. Okay. And then later on, as we discussed earlier, Director Bjornson approved that application that we just looked at, and we have Exhibit 7, which is the board resume for the July 16th, 2025 board meeting. Isn't that correct?
Yes.
Is there, can you tell me what the highlighted item is on that board resume?
It would be the application for Friendship 67 liquor, approved conditionally, Stacy Morrison, and the address.
Okay. And then looking at Exhibit 6, that is an opposition letter, correct?
Yes.
Okay. And what day did the office receive that?
July 15th.
Okay. So that was one day before the board hearing where Mr. Morrison's permit was approved. Do any of the reasons cited in this letter go to public convenience or advantage?
No.
Okay. And what day, just to be clear, did our office receive that and what time?
July 15th at 3:43 p.m.
Okay. I have no further questions.
No question.
Brandy, a couple of quick questions for you. I'm at the hot seat. There was mentions about the previous permittee of Katie. There was comments said that it was discovered later on that she didn't sign some of the documents that were mentioned here today.
Correct.
Was it you? Were you part of how that was discovered? Like you mentioned, she came into the office. Was there a conversation that something was said, or?
She came in to do a replacement application, and we already had a replacement application. So that made us look further and more in depth to the one we had in the office.
And was that a replacement application going to Mr. Jatt or to
Yes.
Mr. Morrison? Okay.
Mr. Jack.
So before she came in at the end and filled out a replacement application with Mr. Morrison, she came in previously and tried to do a replacement application with Mr. Jatt.
She did not come in for that one. She didn't even sign the form. That's the issue with the application. She didn't sign the replacement notice, and that's the only person that could sign it to give them rights to the permit.
So you discovered this when she came in with Mr. Morrison.
Yes.
So she came in with Mr. Morrison to transfer to him.
Mhm.
And it was at that time it was discovered that there's already one in process with her alleged signature on it.
That was
To
falsified.
That
Yes.
was to Mr. Jatt. Okay.
Can I ask a question, follow-up? The replacement notice, who signed that?
H. Jack.
But they didn't sign Katie Tatum forging, acting like I'm Katie Tatum's signature. It was signed H. Jatt. Yes, correct.
Correct, but it's the permittee's signature, and that would have been Katie.
I got you.
And I believe I saw at the top of that.
Yeah.
That's exhibit number 4, Commissioner.
Yeah.
Is Katie denied filling that application out? That first?
Oh yeah, I was here that day.
So she said, I never did.
Well, we're kind of getting into here.
Yeah, just
But like at the, so in exhibit 4, I don't know if you have a chance to see this, it says in the beginning on dated 5/29/2025, and this is the notarized document by Ms. Keene, who seems to have been very busy on this project. I, Katie Tatum, do hereby give 270 Beer Run Spirits permission to operate on my permit until such a time as consideration of his or her replacement application is completed by the Alcohol Beverage Control Division. And then it says permittee signature below that. So the statement is that something was filled out with her name on it that she did not know anything about. And it sounds like she went in to submit the same document, but instead of I, Katie Tatum, give permission to 270 Beer Run, it was to the Stacy Morrison at Friendship Liquor.
I do want to point out that's H. Jatt, not Khalid Jot, and 270 Beer Run and Spirits LLC, which is H-Jat, Hamid-Jat is the president of, so it's not Khalid Jat's signature.
Yes, but it also goes back to the permittee that originally had this license was something was signed that she had it's something record of. My understanding. So, anyway, any other questions? All right, thank you, Ms. Brandy,
Thank
for your
you.
time. Does you have anyone else?
Yes,
Sure
sir.
do.
May you please state your name for the record?
I'm Director Christy Bjornson. I'm the decision maker that brought us all here today.
Director, the first time you had any communication from Mr. Khalid was when you received what's been marked as Exhibit 6. That's an opposition letter. Just to clarify, you received that the day before board, correct?
Yes, we are always busy the day before board trying to make sure we have everything prepared and ready for you guys to go. So we were actually getting ready to leave for the day and making sure that Keisha had everything she needed for the hearing the next day when we received a letter of opposition for board the next day. And so we kind of paused and we're like, okay, I can check that out. The public convenience and advantage factors are listed in our rule book. There's 7 factors. I've been an attorney for a long time. I've been director for 2 years. I know those factors. It's pretty easy analysis to make. If they had brought up those factors, I would have stayed a little late, checked them out, made my decision, same thing. That was a timely appeal. I know that got brought up earlier. But it was kind of did catch us off guard because it started talking about a lawsuit between Katie Tatum and Khalid and Hamid Jat. And so obviously my attorney instincts were like, lawsuit, let me make sure they're not suing me because we haven't received any service, but they're acting like it's an ABC issue. So log on, pull up the complaint. ABC is not listed as a party. We've not been served. It is a personal dispute between the 2 of them. So I looked at the opposition letter. I looked at the complaint with ABC not being a party, not being ordered to do anything by any court whatsoever. I made the standard decision that we would make. If there's no issues with a replacement application, it goes forward. So Mr. Stacy Morrison's documentation was all in line with what Katie Tatum had intended based on her paperwork. As a matter of fact, she'd come in and signed that replacement notice in front of my staff. So at this point, I'd been kind of apprised of the backstory and had got the last minute plea from the other side of the fence, just kind of saying, hey, stop, you can't make a decision. ABC has to make a decision on every application in front of this board every month unless we are prohibited from doing so by a lawsuit. We were not named a party in the lawsuit, so I made the decision to go ahead and approve the replacement notice and application for Stacy Morrison because Katie Tatum is the only person, according to ABC's documentation, who could change the ownership of that building. She is the sole proprietor to the business that was selected in the lottery. So as far as any documentation that we had, Mr. Jat's a landlord.
And Director Bjornson, really quickly, I don't want to go through all the factors. Those are listed in Exhibit 12, 3 Car 1203, but it does mention opposition or support from adjacent property owners or nearby residents. Did you hear from any people before the board met on July 16th?
No, and we always send notification to the prosecuting attorney, the sheriff, and the mayor if there is in that area a prosecuting attorney, a sheriff, and a mayor. If not, we'll send to whatever that jurisdiction has, and they will always get back to us if they have any opposition. Did not hear from any of those interested parties, did not hear from any individual who was opposed to the premise of an alcohol-related facility, only heard from someone who was more interested in the business side of things, not the actual opposition to alcohol in it.
I don't have any further questions.
No questions.
Do you guys have questions for me?
I do not at this time.
Okay, thank you.
Thank you.
I don't have any further witnesses at this time.
You can accept closing arguments if you would like, but I know it's kind of been a lengthy hearing, so if you guys want to deliberate, you're welcome to go ahead and do so.
Is there anything else here?
I have no closing arguments.
I mean, I feel like we had a pretty good in-depth opening argument, so I think all the details are laid out pretty well. So from a procedural perspective on this, just to make sure everyone's on the same page. We would be looking to have a motion. There'd be either upholding the director's decision or overturning the director's decision is what's in front of us today to do, based off of the evidence, admitted and allowed, from both sides. This time I open the floor up to my fellow board members. If anyone that has a motion they'd like to bring forward.
I'll make a motion to uphold it.
Okay. We have a motion. Do we have a second?
Seconded.
Okay. We have a motion and a second. Susan, are you hearing us? Okay.
I can hear you.
Okay. All right. At this time we call a vote. All in favor?
Aye.
Aye. Motion carries. Thank you all for your time today. Appreciate everyone's work on this. Before we conclude, do we need to set the next meeting date?
Yes, we do need to set the next meeting date. We have October 8th listed here. Yes, y'all are released. Thank you. Let me make sure I have that on my calendar. Yeah, we have it on the 8th right now. If anyone has some reason to change it, we're happy to move. We just want to make sure we don't have a quorum issue. Okay, and I think, did Susan say so as well? Or was
She's the next week when we're gone.
Susan, can you make the 8th work?
The 8th of November, we were saying?
8th of October.
Oh, yes. I'm sorry. Yes, that is. I can make that week work. I think we moved it because I have travels on the following week.
Okay, and if we do still have Stacy here.
Yeah, Stacy's on.
Kind of
Stacy, does that work for you?
October the 8th.
Yes. Yeah.
Let me check just 1 second. Yes, it does.
Okay, and Stacy, just to give you like a little bit of a heads up, and then we usually do 3 meetings in advance. So the other 2 that you can go ahead and mark your calendar would be November 19th and December 10th. And then we're looking at setting the January one here today, which would be the 3rd Wednesday would be the 21st of January.
Correct.
If that works for everyone.
Mm-hmm.
Okay. All right, so we'll go ahead and set the January meeting as Wednesday, the 21st. Brandy, are you sending out invites of those?
Yes.
At this point? Okay. I will stop making it on my own, so I'm not getting 2 of them. And I guess will you make a note if we are changing at one of these upcoming ones to the new DFA office?
Yes, I will let y'all know.
And maybe a friendly reminder email the day before in case some of us with ADHD.
Yes, if
Yes.
there is a location change, we'll make that abundantly clear. Thank you for bearing with us as far as technology. Y'all know that's not my favorite thing in the world. And we keep having different systems and different people working on it. So I do think it might be better to move to that new board meeting room once they get it ready. But I don't actually know when it's going to be ready.
Well, and it's totally you all's call on if you want to try it. We're happy to help. If it makes it too much of a burden on you all to lug everything over there, we're happy here.
Perfect. And then one other thing I did want to bring up, I know I've brought this up before. ABC doesn't love having hearing officers, or has historically not loved having hearing officers. Most of our hearings on violations, pretty cut and dry. The agent presents the evidence, and that's really it. But when we have hearings like this on ownership stuff, do you guys think it might be helpful to have a hearing officer just to kind of keep everybody in line? Or
I mean, I think it kind of leaves it up to you all if you feel like it's going to be a contested, heated type thing, that there's heavy opposition,
if we feel like it's going to be lengthy and kind of a big deal, go ahead and look at one would be
Yeah.
okay.
Yeah, that's totally up to you guys.
Okay. I just think sometimes I'm trying to protect my staff, because sometimes when you're arguing a case, it's hard to argue the case and be the hearing officer at the same time. So just sometimes it's easier to have an attorney up there who rules just on evidence. But I know that we haven't typically done that here, and we don't have to do that here.
I was going down a whole other path with that. I was thinking of like an officer to like.
Oh no,
Okay.
it's essentially like a judge. It's an attorney. Cameron is actually one. He's our tobacco attorney, but he'll sometimes have to go to, what was your last one? Like the counseling board.
Counseling board, CPA board, stuff like that.
So he'll be the one who basically runs the hearing as if he was the judge. He doesn't make any of the evidentiary calls. You guys still decide whether you want to let stuff in. Actually, if you're a hearing officer, you do make
the
those calls.
evidentiary calls, but the board is the fact finder.
But the board has to still say whether you think it occurred or not. So we could try it out if y'all wanted to. I think the whole time ABC has been operating, they've never had one, right? Not once. So it would be something new.
I mean, I think that, if it's not broke, don't fix it. But if you do feel like it's going to be one of these cases where like high likelihood of it being like challenged at like a circuit court type thing, and then it's something we could put it in as like an extra safety measure to help get CYA.
Okay.
But on a normal basis, I think it should be okay.
Okay.
And I'll defer to you. We, fly pretty blindly into these, so it's hard to know from our side going in, which is obviously how it's designed. But so y'all just make that call and we'll get whatever you
Okay.
want.
I just didn't want to spring something new on you guys without having brought it up, because I know we have talked about it
That's
before.
your call. I feel like that's your call.
Yeah, I think it's. I mean,
otherwise you're running it if
Right.
you don't
I mean,
have a.
Yeah.
Yeah.
And I know that puts a lot of pressure on y'all, and y'all are trying to pay attention to the evidence, so then you kind of look to us, and so I just.
I think like on a normal case, it's okay. This is,
Yeah.
a little unique, but again, like if it's going to be something that's like really heavily scrutinized, like I'm not opposed to it coming in,
Okay.
on a case by case if something's like.
We'll try to let you guys know if we think there's one coming like that. And so I guess if you see an email that says we're planning on having a hearing officer, you should know that one might be unique. Is maybe the best.
Well, and if need be, if you want to call me before the meeting starts on procedurally what I need to do differently to make sure that I'm not, we're seeming like we're a cohesive unit
Sure.
on that.
All good. And if there's anything you guys want us to touch on in future meetings, I didn't add a lot of extra stuff into the PowerPoint this time because we had a hearing, but you guys all know if there's not a hearing and there's something specific that you want to run down on or you want to discuss, we can always add it to the agenda and do some research.
We have 2 next month now.
2 hearings set for next month, Brandy, or
Maybe
just
one.
maybe one? There was a set of hearings on a marijuana applicant, I believe, that had kind of popped up and gone away. That's because there's a long-term health issue. So we agreed to a more substantial, so that's not going to pop back up until I think after the end of the year.
Okay.
I don't know if this is something we talk about on the record. You can stop me, but I guess I'm going to bring it up on the record, and someone can stop me. I think the most alarming thing that we looked at today is this application. Is this something your office investigates further?
So we do have options for this, and we've run across it on the tobacco side before, where occasionally we have seen some sketchy signatures, maybe a brother pretending to be another brother. In this case, there was a son who is involved as well. We believe that to be his signature. Sometimes our document examiners, some people's signatures are like just scribbles and you can't really tell. So we really rely on that notary stamp. So maybe a document examiner just kind of flipped through and looked at it. Now you've got 3 prosecutors sitting in this room. And so we're all thinking, forgery? Like, what's going on here? That is our discretion on if we want to turn it over to the prosecutor's office. I believe there was one on the tobacco side that we strongly considered. Did we turn it in? We did not turn it in, but we considered it. It just kind of drags us into a criminal case. And most of the time, if we can head off the bad behavior and get them out or unapproved, then we know in the future we need to second look at all of these documents for him. Because we know he has other beer permits. But it is an ABC violation to provide false or misleading documentation. So if we do run across that.
What if you just enforced it through his other beer permits?
I don't think we can do that because it's in association with this permit, which technically he didn't have any ownership to. Katie did.
Got it.
So if he provides false and misleading documentation in regards to one of his other permits and we catch it, he could get a violation on that permit. But since he actually has no responsibility to this permit, we can't use it to enforce that. So the only option would be criminal if we wanted to call the prosecutors and turn them in on a C felony.
But like on a normal case like the ones today, the board has the discretion to do more than just what the director has laid out before. So like, if this was like a normal case,
With a
A
violation.
with a
violation here.
violation, and he's appealing a fine and a probation period, and then they pull up this evidence of like, everything in a similar scenario today. The board has the discretion to go as far as like, well, you're trying to appeal a $500 fine. This is egregious enough of a thing. Let's suspend or revoke the license. And the board has the ability to go beyond.
You can always go up or down. So if I say someone is suspended for 6 months, but you guys hear the case and you actually think that's a little harsh and you want to do 3, you can go to 3. If you hear the case and you think that's really bad behavior, they need to be revoked, y'all can do that too. Our director decision is my decision based on my judgment and what I think is appropriate. So obviously it's what we think is the most appropriate and reasonable outcome to the case, but you guys still have your discretion to go forward. There also may be some fact that comes out in questioning that we didn't know beforehand. And so it could be that the attorney at the end of the hearing is like, we originally offered $500, but after hearing the defendant's testimony, we want to offer $5,000. That could happen.
And we can come up with that on our own too.
Yeah, that to me is the most alarming piece.
We see a lot of things also with the directors where it's like sometimes they have to, by regulations, deny or have certain sentences, and like former director or chairman before me, who's from Lake Village, had a strong feelings on. We got a lot of cases where people were outside of like the radius by like a little distance, but they're like driving every day to, they want to live in one town to have like a good school for their family, but it puts them outside the radius of like by statute of where they can be at. A lot of those times, like by law, the ABC can't approve or will like deny something because of a distance type thing. And so a lot of times within reason, leniency will be granted for like cases like that where it's trying to help someone out. They're like, well, like they have to on their side, but we can overrule the director's decision.
But technically, if you're overruling to violate the law, you open the entire agency up to liability. So if someone in this chair is telling you legally can't do that, you should listen to them.
Yeah.
But we will always let you know where that line is. Sometimes you can only go up to 5,000. Sometimes you can only go up to 2,000 statutorily, I think, on sale to minors. So we'll always tell you where that line is. But you can generally always suspend and revoke it.
Yeah. Yeah, we can't go and make it a $50,000 fine. You can suspend and revoke.
Right.
Any violation runs the risk of a revocation. Any one violation, the
Even if
penalty.
it's, failure to have your server awareness form. If there was something egregious enough that you guys thought we're pulling this permit, you have the right to do that, even if we only offer a $100 fine.
Well, and it could be like when you have these naughty lists that someone's been here in the past, and they have like in the past 4-page long type things, and it's like, you do one more thing, you're going to lose your license. It could be something like, okay, well, something little, on paper looks like, why would they get revoked over that? But it's because of this history of what they've done to the community around them, that it's not protecting the public and serving the best interest of communities.
And y'all could catch on to that sometimes in the offers we make, but oftentimes too, the attorney sitting there arguing the case is going to tell you like, this has been a problem child for us. They've been in front of this board before. And so that's why it's always hard too when you get a objection based on relevance, because it's what do y'all want to hear, really? Do you think it's relevant or not? Because technically, if we're here on violation number 5 today, we're only talking about violation number 5. There's an argument that only violation number 5 is relevant, but these people operate in this industry for a long period of time. So I would say that violations 1 through 4 are also relevant.
I've got a question. Could we have not today, so we said, hey, the opening, the public advantage, we said, hey, it's not applicable here. Could we not just made a ruling at that time versus?
You still have to come to a conclusion of law. So something would have had to have been presented to you. If he had made a clearer withdrawal to stop, but it's kind of hard. Again, it's kind of hard in that scenario because you guys don't know the backstory yet. he hadn't shown his exhibits to our attorney, so she had less than 3 minutes to review them. Any good attorney is probably going to object at that point. I don't know what you're trying to get at with this. So we figured he would bring up those factors. We figured he would bring up some additional information that we were prepared to address, but step one for an attorney is always to try to cut that out. So if you guys had been like, no, we're not accepting them, and he had said, I want to for sure withdraw, technically we would still want to make some sort of argument to you so that you would come through with the conclusion of law saying absolutely no evidence was presented to show XYZ. And we might have to get creative in the way our order looks.
We would have
If he
had,
withdrew, he just wouldn't be able to object to anything.
there has to be a finding of fact and a conclusion of law in any of our orders that we do. So we had to at least give you the reasons why Christy made her decision.
Gotcha.
Because even if he had that opposition, so if that was the case, what his opposition was, regardless of the public convenience, what all of those things, here are the factors Christy uses. Here's what that didn't include that. Here's why Christy made her decision, because you guys have to decide whether or not to uphold the decision that she's made. So we need to know kind of why she got to her decision, what the conclusion of law is.
We would have had to present some evidence for you to come to a conclusion of law is really the basics. But that is to protect the agency if we are further sued in circuit court and there's nothing on the record for them to look at. Then they could say that ABC made an arbitrary and capricious decision because they didn't consider any
And
evidence.
make us do this again.
Gotcha.
So we just try to prevent something from bumping back down to us.
And that's why I was kind of pushing like get it all the way through because there's already stuff in the circuit court. It seemed like this is a litigious group, but it could easily put more burden on everyone in the long term to try to cut it short. But if he was to withdraw before you even started, then that'd be a different scenario.
Correct.
Because it's once we start, it's kind of opening Pandora's box. You have to get to a certain conclusion point.
Correct.
And if he would have withdrawn before we started the hearing, then yeah, we would have just been done for the day.
Yes, but a lot of times too, and to be fair, there are not a lot of attorneys who work in alcohol space specifically or administrative law, and everybody kind of does administrative hearings differently. So I don't believe that this gentleman had ever experienced an administrative hearing before. So sometimes they don't know exactly how to maneuver their objections, especially when there's not a hearing officer, which kind of brings me back to that point.
Well, and you have a lot of these cases where it's like in these small towns and like the attorney is like, has done something for the defendant, or the permittee in some capacity, and he's like, hey, can you help argue this case? And they're in here and they're like, Your Honor, and there's a lot of random things you can tell like things happen.
You're out, stuck poop.
Sorry, you broke up, Susan.
No, I was just going to agree with Alex. I appreciate this conversation.
So there's you can tell usually pretty quickly who were like attorneys that have done a lot in this and who were like, this is their first time in here. And really MMC attorney cases, there seems to be a lot, they're always like very buttoned up. There's a lot more writing on the MMC cases a lot of times too. So like you can just tell the difference between.
They also are like constantly working with that person. I think a lot of times for our hearings, you get a violation and you immediately say, I need an attorney for this. And somebody that you've maybe never met before, has never done anything for your business, and you just need an attorney because you're getting a violation from ABC. And so you hire someone. Whereas like in the marijuana space, they're working with their clients all the time on different things.
That is true, but oftentimes we see the people come in without attorney as well, which makes it even more difficult. Cameron sees that a lot in tobacco, and that's why we like our hearing officer, because sometimes, they come in, they represent themselves, and so they don't know the difference between an opening statement, questioning, or them testifying. So the hearing officer kind of helps explain to them, like, okay, now here is your time to summarize your case. And then when they start testifying, the hearing officer will jump in and say, we don't want you to testify, just give us a general overview. And then when it's their time to ask questions, the hearing officer kind of a little bit more hand-holding to help them along. Because a lot of times you will see people without attorneys on just like $500 violations or something. If they don't want to pay an attorney, they'll come in and argue it themselves.
You have one?
Yeah. Well, I think we got a lot of new members in here and a new one joining next month, so it's good to have. I had no idea when I walked in on a lot of this. It's like a year and a half.
Well, same. When I got here, I was like, okay, so did the board members like have a training? And Brandy was like, no. And I was like, so we tell them what to do? She was kind of, yeah. So, but we can always, I know we've kind of talked about this in the past, Drew and I can look at putting in some slides every now and then on, what is ex parte communication? What is proper objection? We can kind of give you guys a little bit of lesson when we don't have a hearing, talk about some stuff.
How do you decide if it's a roll call vote or not a roll call vote?
I mean, if it's something that it's going to be like, in my opinion, what I've seen in the past is the more that it's going to be a case, it could be like something brought up in the past of like it could be good, like challenge of the circuit court. You want to do everything very methodically to get it, get as much data on the files moving forward. But I don't know if really anywhere it's more of like a, what is your vote? What is your vote?
If you were split,
Usually if it's, sorry, you were saying it, Chrissy. I was going to say if it's unanimous, you don't need it. Roll call.
right. But if you guys were split, there could be an occasion where just everybody's saying aye or nay at the same time. We're like, okay, we just want to make sure we know you were an aye, you were a nay. There may be an occasion when we do that, but most of the time y'all are a small enough board too. We could generally, Lila's over there taking the minutes, so she knows who makes the motion, who seconds. She's watching when you guys vote, so we normally know what's up. And then that's also included in the record.
And then it was, this was like a procedural thing that like Chairman Black did before me, but historically, you were to kind of like run the meeting, call the vote, and with it being a board of 5, usually if it was, he would kind of abstain as being like the last one to vote. If it was like 2 yay, 2 nay, you kind of be in the swing.
Yeah, that's the chairman's special. MMC does that a lot too, and it is chairman's prerogative to, and I've seen a lot of chairmans do it. Do I have a motion to kind of leave it to the rest of the board to talk? And then if it does look like it's going to be split, then the chairman ultimately is kind of the deciding vote. But I've seen it happen other places too, where the chairman just goes ahead and speaks up.
Yeah, and when we've had empty seats and close to not under a quorum, I kind of just do it with everyone at that point because everyone's going to be a part. Right. So awesome. I think at this time we are concluded. Thank you all for your time.
Thank you guys.
We'll see y'all on the 8th.
Thank you for driving down and coming in. I know it's not always easy for you guys.
Hey.
Susan.